Getting denied for supplemental security income can feel like the ground has been pulled out from under you. You applied because you needed help, because the financial pressure was real, and because you believed you qualified. Then the letter arrives, and it says no. That moment is frustrating, confusing, and for many people, genuinely frightening. But here is the most important thing to understand right away. A denial is not the end of the road. In fact, the majority of people who apply for supplemental security income are denied on their first attempt. The Social Security Administration reports that initial denial rates hover around 60 to 70%, which means most applicants are in exactly the same position you might find yourself in right now. The system is built with multiple layers of review, and many people who are ultimately approved only get there after going through the appeals process. So before panic sets in, take a breath, because there are clear, structured steps you can take to fight back against that denial and potentially turn it into an approval. Before you can effectively appeal a denial, you need to understand why it happened in the first place. The Social Security Administration denies supplemental security income claims for a wide variety of reasons, and not all of them are related to whether you are actually disabled or financially eligible. Some of the most common reasons include missing or incomplete medical documentation, income or assets that exceed the program's limits, failure to cooperate with the Social Security Administration's requests for information, or a determination that your medical condition does not meet the agency's definition of disability. There are also technical denials, which happen when someone does not meet the non-medical requirements of the program, such as citizenship status or residency. When you receive your denial letter, it will include a specific explanation of why your claim was rejected. Read that letter carefully and more than once. It is the roadmap for your appeal. Understanding the exact reason for the denial tells you what evidence you need to gather, what arguments you need to make, and what mistakes, if any, were made in the original review of your case. The Social Security Administration has established a formal appeals process with 4 distinct levels, and each one gives you another opportunity to have your case reviewed. The first level is called reconsideration. At this stage, someone who was not involved in the original decision takes a completely fresh look at your claim. You can submit new evidence, new medical records, and additional documentation that supports your case. Reconsideration must be requested within 60 days of receiving your denial letter, plus an additional 5 days that the Social Security Administration allows for mail delivery. If reconsideration also results in a denial, you move to the second level, which is a hearing before an administrative law judge. This is widely considered the most important and effective stage of the appeals process. You appear in person or via video conference before a judge who reviews all the evidence, hears testimony, and can ask questions. Many people who are ultimately approved for supplemental security income receive that approval at this stage. The third level is a review by the Appeals Council, which examines whether the administrative law judge made any legal or procedural errors. The fourth and final level is filing a lawsuit in federal district court, which is the most complex and time-consuming option, but remains available if all other avenues have been exhausted. One of the most significant things you can do to improve your chances during the appeals process is to work with a qualified disability attorney or a non-attorney representative who specializes in Social Security cases. Studies and statistics consistently show that applicants who have legal representation are significantly more likely to be approved than those who navigate the process alone. A disability attorney understands the specific medical and legal criteria the Social Security Administration uses to evaluate claims. They know how to gather the right evidence, how to frame your medical history in a way that aligns with the agency's standards, and how to prepare you for the hearing before an administrative law judge. Importantly, most disability attorneys work on a contingency basis, which means they do not charge you anything up front. They only get paid if you win your case, and their fee is capped by federal law at 25% of your back pay, with a maximum of $7,200. This structure makes legal representation accessible even to people who are struggling financially, which is exactly the population that Supplemental Security Income is designed to serve. Whether you are working with an attorney or handling your appeal on your own, building a stronger evidentiary record is absolutely critical. The Social Security Administration's decision is based almost entirely on documentation, so the more thorough and detailed your medical records are, the better your chances. If your denial was related to insufficient medical evidence, your priority should be getting updated records from every doctor, specialist, therapist, or healthcare provider who has treated your condition. Statements from treating physicians carry particular weight. A letter from your doctor that clearly explains your diagnosis, the severity of your symptoms, how your condition limits your ability to function, and why those limitations prevent you from working can be one of the most powerful pieces of evidence in your appeal. You should also consider gathering statements from people who know you well, such as family members, caregivers, or former employers, who can speak to how your condition affects your daily life. Every piece of documentation that paints a clearer picture of your limitations strengthens your case. One question that comes up frequently is what happens to any benefits you might already be receiving while your appeal is pending. For Supplemental Security Income recipients who are being terminated rather than denied for the first time, there is an option called continuation of benefits. If you request an appeal within 10 days of receiving your termination notice, you may be able to continue receiving your benefits while the appeal is reviewed. However, it is important to understand that if you lose the appeal, you may be required to repay those benefits. This is a decision that requires careful consideration of your financial situation and the strength of your case. For first-time applicants who were denied before ever receiving benefits, there are no continuing payments during the appeal. But if you are ultimately approved, you may be entitled to back pay covering the period from your original application date. A denial from the Social Security Administration is not a final verdict on your worth, your need, or your eligibility. It is a procedural setback in a process that is notoriously difficult to navigate on the first try. The appeals system exists precisely because the initial review process is imperfect, and thousands of people every year successfully overturn their denials and receive the benefits they are entitled to. The key is to act quickly, because deadlines in the appeals process are strict, and missing them can cost you your right to appeal. The key is also to be thorough, because the more complete and compelling your documentation, the stronger your position becomes. And the key is to seek help when you need it, because you do not have to face this process alone. Whether that help comes from a disability attorney, a legal aid organization, or a trusted advocate, having someone in your corner who understands the system can make an enormous difference. Your situation is not hopeless. The path forward exists, and taking that first step toward an appeal is the most important move you can make right now.